It was standing room only at the FKAA board meeting today. The board's agenda promised a showdown between Chairman Bob Dean and the most recently appointed board member, Attorney Kara Higgins. We had reported a couple of weeks ago in the Blue Paper about the resignation of board member Melva Wagner, who apparently had continued receiving FKAA board member benefits even though she had moved away from the Keys. Last week, an investigation conducted by Blue Paper contributor Colby Fisher into whether Chairman Dean truly resides in Key West prompted the state attorney to challenge FKA Board Chairman Dean's right to vote in Key West elections. In this packed boardroom at 10 a.m. this morning, board member Kara Higgins is about to question whether Chairman Dean can legally represent the Key West District as per his governor appointment.
Resignation due to residency issues, with regard to, and certainly this isn't personal, Mr. Dean, but Mrs. Wagner received overwhelming public attention from the press and also from our ratepayers and the taxpayers in our community with regard to her residency and her continued service on the board. After Mrs. Wagner resigned, it appears that questions have been raised about Chairman Dean's residency. A concerned citizen by the name of Colby Fisher, who is someone that I want to make sure that I note, did write an article for the Blue Paper several months ago. He did a story regarding his application process to the Aqueduct Authority for a position that it appears he was qualified for. The position eventually went to Randy Acevedo and then Christy Fritz, it looks like. Mr. Fisher brought several public records and documents to the Aqueduct's attention. During the course of Labor Day weekend at the end of this August and the beginning of September, I received numerous messages at my FKAA email address that had been quarantined by the Aqueduct, and it was necessary for me to contact Mr. Zulch and also our IT director so that I could read the emails that Mr. Fisher had started sending. He clearly spent a considerable amount of time and research with regard to Mr. Dean's residency, and he found, among other things, that in 1986, when Mr. Dean was originally appointed to the board, he served in the Lower Key seat, which is the seat that I serve as I live in Key Haven. Mr. Dean held that seat up until about 1993, when he switched to the Key West seat, and it looked like maybe that was to accommodate a former Key West Mayor, Kermit Lewin. With regard to Mr. Dean's residency, Mr. Dean's made statements to the state attorney's office indicating that, that he and his wife built a house in Key Haven in the late 70s, and, he's admitted that he eats most of his meals there, receives his mail there, registers his cars there, gets a homestead exemption since 1982 in the amount of $50,000. The property is owned by him, he and his wife, unlike the Bahama Street property, which is not owned by Mr. Dean, but by a trust. Mr. Dean's driver's license, occupational license, residential telephone number, and U.S. mail are all listed in Key Haven. And Mr. Fisher also provided the Aqueduct with statements that Mr. Dean has signed under oath with regard to loan documents, purchasing vehicles, deeds, wherein he states that he lives in Key Haven. Mr. Feldman, our board attorney, was one of the signers on one of those deeds. And it was also notarized by Deanna Espinaldo, who is the wife of our internal compliance auditor. It appears Mr. Dean registered to vote in Key West in 2004, 37 days before he was appointed to the District 3 seat by then Governor Jeb Bush. And that was when his voter registration card was changed. Our state attorney, Catherine Vogel, has challenged Mr. Dean's ability to vote in the upcoming election and says that she has reason to believe that if he does attempt to vote, she challenges the legality of that. So with regard to residency, I have tried to do my research, and it's certainly subject to some interpretation. It does appear that intent is a factor, but that our Florida attorneys general opinions over the years have stated very clearly that intent must be factually supported. Mr. Fisher also obtained documents from our agency that suggest that in a period of 20 months, 100 gallons of water were used at the Key West address. 100 gallons of water over the course of 20 months. 100 gallons of water is the normal usage for an individual every day. So on September 10th of 2015, Mr. Zelch was on the radio and made some statements about Mr. Dean's residency, saying that this wasn't a new issue and that he was aware that it had been brought up previously. But he didn't say who brought it up previously, and he didn't say what governor it was brought up to, whether it was Governor Christ, Governor Bush, or now Governor Scott, who would obviously make any decisions about this particular appointment. So I contacted our board attorney and asked whether or not this board has ever formally addressed the issue of Mr. Dean's residency in light of the fact that our governing documents are very clear and that we have to have a representative from one of each of the 5 districts. And that would be our enabling legislation, which is in Chapter 76, which states that the board of directors shall consist of 5 members who each represent one of the 5 districts of the board of Monroe County. Mr. Feldman did not want to give me his legal opinion. He said in an email to me that he said, I do not feel my opinion has any bearing on the actions of the state attorney or the governor. I then asked him again if he would please answer my questions as to whether or not the boards ever formally addressed this issue and whether or not the aqueduct or the board has ever brought this to the attention of Governor Scott. And I asked Mr. Feldman if he would give us an opinion, give us some guidance as the board attorney as to how we handle this. If we have an overwhelming amount of evidence that seems to suggest that one of our board members doesn't live in the district that he was appointed to represent, what does the board do? Does the board have a legal or an ethical obligation to report that to the governor? Does our board attorney have a legal or ethical obligation to report that to the governor? Does our executive director, who's also an attorney, does he have an obligation to report that to the governor? We have an internal compliance auditor who is charged with making sure that that we are in compliance with established policies, applicable laws, and regulations. His job is to review activities and determine whether their compliance with FKAA policies and procedures, applicable laws and regulations, and contracts are being followed. And I haven't received an answer to that question. I know that Mr. Feldman spoke with the Florida Bar, an ethics person from the Florida Bar, and asked for an opinion, and he directed me to rules 4-1.13 and 4-1.19, and those have to do with obligations for attorneys that represent organizations as clients. And does that attorney, if the attorney knows that someone that is involved in the organization, especially a government organization, is not following the rules or the law, does that attorney have an obligation to then report that conduct to the highest authority that can act on behalf of the organization, or do nothing? So that was why I added this item to the agenda, and I await a response from Mr. Feldman with regard to how the board should handle this and whether or not it is your opinion that Mr. Dean's residency serves as a problem for him in continued board service.
Anyone else have any comments from the audience?
I do, sir. I've signed up to speak.
My name is Michael Halpern.
Attorney Michael Halpern, representing Bob Dean, argued that the Key West Canvassing Board, overseeing city elections, would soon provide the answer. He accused Kara Higgins of waging a personal vendetta.
I heard your presentation, and I'm representing Mr. Dean, and I didn't hear one word about that conflict of interest. And that is the main issue here today. If everybody wants to lay cards on the table, let's be honest with everybody. You're the last person who should be raising the issue of Mr. Dean's occupancy, even though it's been gone over twice with the
Former governors?
I understand your contact with the current governor because you're on the board with this current governor. So now we have a double conflict of interest. You're powerfully enough connected so that you can reach to the governor's office, get appointed to this board, and then when you have a conflict because you blame this board for the venture out. I'm sorry, ma'am, that you got terminated from your representation of venture out. And I don't know what it is that made you get terminated from your representation of venture out before this board. But whatever it was, another lawyer came in, finished the job, and they were able to get an agreement. And that should not be grounds for you going after Mr. Dean and his ability to sit on this board. But you don't have to continue the charade of asking Bob Feldman for an opinion, because in just 10 days, there will be vote in Key West, Florida, and Mr. Dean will vote, and Mr. Dean votes, it will go to the canvassing board. And if they say that this man should not be voting in this district, if the canvassing board says this man should not be voting in this district, then I say on the record he should resign. But the corollary question is, if they say he's absolutely correct, should you resign? Because political vendettas are not good. Thank you.
Are you keeping time?
We're not keeping time for Mr. Halpern. If I may just respond to Mr. Halpern. With regard to venture out, my partner David Horan is here, and maybe he can assist me with this, but my understanding was that we represent, my firm, my law firm, David and I and other members of my firm represented venture out. We represented venture out for several months, and I do believe that we spoke with administration about a settlement agreement that Mr. Horan drafted, which was essentially the same settlement agreement that was later accepted by the board, but that we, the client decided to go to Bart Smith's law firm prior to the board taking any action on the case at all. So I believe it was just administration, which doesn't really make sense that I would have some conflict or some vendetta against the Aqueduct Authority Board of Directors, considering the fact that the case never even made it to the Board of Directors before I was out of the case. I had never met Mr. Dean before I was appointed to the board. I ran, threw my hat in the ring to serve on this board for a reason, and that is that this organization has had some major PR problems in the past several years, probably since 2011 when administration was changed. And I had heard things about the Aqueduct Authority, which was what drove me to throw my hat in the ring for the board. So I don't think Mr. Halpern has his facts correct. And as lawyers, you know, sometimes we joke about the fact that when we have cases and the facts are in our favor, we pound on the facts. And when the law is in our favor, we pound on the law. And when neither the facts or the law help us, we pound on the table. And that was a demonstration today by Mr. Halpern of that. I certainly had nothing to do with producing the copious amounts of documents that Mr. Fisher produced, which calls Mr. Dean's residency into question. The Attorney General opinions are very clear, and I certainly didn't make a motion. All I did was ask for guidance. As an officer of the court, I cannot sit on a board and bury my head in the sand when people tell me that someone may be violating the law. So, in response to your questions, Mr. Halpern, you know, respectfully, I don't think that whether or not the canvassing board determines that Mr. Dean votes legally is the same thing as residency, with regard to our governing legislation, which requires that you live in the district.
So does voters
Mr.
registration.
Chairman, could I
Mr.
comment? So, just a few general thoughts. I know when I homesteaded my property, my intent was that's my primary residence. That's why I homesteaded it. And so I can't project that intent on others, but it is a strong indication if you homestead a property that that's your primary residence. So whether that's legal or not legal, I can't say. I'm not sure it's Mr. Feldman's job either. We are all appointed by the governor. The governor has an attorney, the Attorney General. I agree with you. I don't think the canvassing board, it's interesting what they say, but they don't oversee us either. So we're appointed by the governor. We serve at the governor's pleasure. And the governor has an attorney. And if anyone should look at it, it's my thought, if you want a definitive answer, it should be the Attorney General to give us a definitive answer. And I don't know what anyone else may think about that, but if you want to look at it, that'd be a suggestion.
I also have a comment, and I do object to the procedure the way it is going now. When I came into this room, I was coming to a boardroom, not a courtroom. And it just offends me the way that this is going. So I would just hope that we could put it to rest.
That's why I intended to handle this internally and ask Mr. Feldman for guidance. Our ratepayers pay Mr. Feldman over $150,000 a year to serve as board counsel. And I asked him for a legal opinion, and he wouldn't give me one.
Is your board and your administration and your counsel and your director, and the public sitting here is telling you, we don't have faith in you, that there's no transparency, and you who serve to do what's best for the community, you should really be concerned about this. I don't have any personal, this is not a witch hunt, I don't know Mr. Dean, but what we want is honesty, transparency, and trust in your board. And when we feel like we have been stonewalled by your attorney who has not listened to Mrs. Higgins' request for determination, we don't want to come here and bicker. You have bigger problems to deal with. So I think you need to pay attention to the bigger issue. Yes, we do have a residency issue. Yes, that's going to work itself out. But these people are telling you, we have lost faith in you. What are you going to do about that? Thank you.
Hello, I'm Jeff Sharp from Big Pine Key. I wanted to say I came here as an observer. I had no intention of speaking. Also, it was Mr. Feldman's passionate representation of Mr. Dean that sparked my interest. Regardless of whether her vengeance or her duty as an executive officer of the aqueduct, when she gets public comment from the public to ask her questions, it's her responsibility to ask the attorney and represent the public. Regardless of whether it's vindictive or not, I think that she was doing what she was told to do by her constituents.
Thank you.
The information we have about Bob Dean's residency to the governor's office, and it comes from the board.
Ms. Higgins then made a motion to submit the question of Chairman Dean's residency to the governor's office. The motion passed with the support of Chairman Dean.
Any further comments? We have a motion and a second. I'm releasing Mr. Feldman from the many obligations for attorney-client privileges. I'm not going to discuss this. I am going to vote for it because I wouldn't want to object to clearing the air. It's been done 3 times already, so this will be coming up on the 4th time. But I will vote for it so that Ms. Kara can have her answer. So any further discussion? Without objection, it carries. Next item.